Hello, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation uh, for injured workers. Today's podcast is called the Injured Workers Legal Side Podcast with Richard and Paul. And I'll turn it over to Paul to tell you what the topic is.
Hello, everyone. My name is Paul Taylor, and I'm a paralegal who spends a great deal of time helping injured workers with the Workplace Safety Insurance Board and the Tribunal with a specialization in human and charter rights law. If you want to reach out to Richard or myself or be part of our podcast, you can contact either one of us through the links below. Today's topic is the WSIB and human rights.
The This is a human rights code is something that comes up in our law practice from time to time when people say, I was terminated because of such and such disability, and we suggest going to the tribunal. But I never thought of using the Human Rights Act in Ontario as a way to litigate against both the employer and the WSIB regarding workers' injuries.
Yeah, some important things that people need to know about. First of all, you do have human rights as well as charter rights. And the significance of both documents, as you know, Richard, is they're primary over all other laws in Canada. With the exception with the Human Rights Code, it doesn't have an absolute primacy clause as you experienced in, that famous case you had done for age. So the Human Rights Code is primary unless that law says otherwise. So, in a good example is in Ontario, the Workplace Safety Insurance Act, the workers' compensation law, actually does exempt discrimination based on age. However, it doesn't for disability and other things. So, if you have a claim of disability, oftentimes you'll hear the board or the tribunal or somebody say, well, no, we just have to follow our policy. Not true. They have to follow their policy, the law, and also the Human Rights Code and the Charter, and they're just not doing that, it seems like.
Well, for me, the eye opener was a WSIAT case I read about 2, 3 weeks ago. And I'll give the audience the number, which is 42824. And what the worker was proposing was that he sue his employer for causing him psychological harm and discriminating against him based on his psychological situation. And if you would have asked me whether his case of a lawsuit against the employer under the Ontario Human Rights Act would have been allowed, because essentially what he's doing is he's getting around the workers' compact. By the workers' compact says if the employer causes you an injury, you have to go through workers' comp. The case he was saying in the case, that is the injured worker saying in the case, I don't have to go through workers' comp. I can go through a lawsuit and sue you under the Human Rights Act. And I would have guessed that the appeals tribunal would have knocked down the case, but they didn't. In fact, they approved the case. So what they said is the Ontario Human Rights Act was passed after the Workers' Compensation Act. Therefore, it's new law and it's not covered by the Workers' Compensation Act. So in this case, the worker was allowed to sue his employer for psychological damage caused by him being discriminated against.
Well, I'd also
To
add,
me, that
Richard,
was that was news.
yeah, I'd also add there's 2 points to that. Is one is that there's the primacy clause in the Human Rights Code, and that's maybe what they were looking at. But I really honestly think if that was a very new decision, I think it's maybe the tribunal was thinking about that famous case of Morningstar v. WSIAT, and that's where the divisional court overturned the WSIAT's decision, where the worker was suing their employer for wrongful termination and workplace harassment, and the employer in the WSIAT said, no, no, this is a work injury. And the divisional court said, no, actually, the worker has a right to sue the employer. So it really opened the door in that way, I think. So I'm thinking maybe because when you look at human rights in a way, in my view, it is literally a civil law. In fact, if you're already bringing a civil claim in Ontario, amended the human rights law that if you were bringing, say, a wrongful termination claim against your employer in civil court, small claims court, or superior court, that you can actually add to it a human rights claim with it. So that's quite interesting because then as you're pleading your case, you don't just have one issue, you can add another and then plead up the damage award.
Let me take another case that it was one of our clients whose case I was reviewing last week. The worker works at a pharmacy, which is a national chain of pharmacies. And he's there in the front desk filling out orders. And somebody comes into the pharmacy and beats the crap out of him for no reason. Obviously, the person who does the beating is deranged, and the person who does the beating can't be sued. He has no assets. So the worker is told, go back to work. We're going to put you in the back room. You won't have to deal with the public. His doctors all say he really needs to work in isolation. The board says, no, you don't, and they cut him off. And then, in order to eat, because he's got no money at all, he starts doing Uber driving. So he's in a car doing an Uber driver with the person in the back seat, and they're sort of quasi-walled off from him. And the board says, you see, you can deal with people. You don't have to work in a home environment or work online. You could work in the back room of the pharmacy with other coworkers, which is against what his own psychiatrist is saying. And the obvious question for me is the board is being terrible about how they're dealing with him. But beyond that, can I sue the board? They're violating the Human Rights Act. They're not allowing accommodation of someone with psychological disabilities. They're making up this Uber story. Or can I sue the employer who've been fighting all along saying, yeah, come back to work or else? I've never thought about suing in these cases till the last few weeks.
I would add too, though, Richard, to that case where the board, the case manager, I presume, is saying, see, you're fine. You can do, well, they're medically saying you're fine. And I would refer to the Fiera v. WSIAT case where the divisional court says that decision makers cannot ignore medical evidence and put in its place their own personal opinions because they're not medical people. They're decision makers. They can only weigh medical evidence, which then gets back to that other WSIAT decision 1229-19 at paragraph 66, which gives the test of how they're supposed to weigh medical evidence. Instead of just saying, honestly, let's just say they're saying, I think you're faking, so I'm just going to make up or say this, which I think is a real problem, Richard, may be a subject of another podcast, is the issue of faking. I've actually identified 5, 6 different terms the board has used for faking. But getting back to the human rights, I just want to add some important points too about bringing a human rights application is one that when the incident occurred, you have to file your application with the HRTO if that's the route you're going within 1 year. If not, the Human Rights Tribunal will dismiss your application. Now, many people will say, well, I was waiting for the board and the tribunal to decide. And there was a recent decision from the HRTO said, no, that does not pause the time limit. You must do it from the date of incident, and that's not you know how they say, Richard, it's from the incident or from the last ongoing incident. So they're saying those aren't ongoing incidents. I respectfully would disagree with that because if the appeals board at the WSIB is saying there's no discrimination, and if the WSIAT says that, that in itself, to me, is discrimination. But I digress. The reality is when the incident occurs, when the case manager or whoever is doing the discrimination, that's when the clock starts ticking. The other important thing is, as you know, Richard, is when you plead a case in civil or human rights or anything, is you're always told you shouldn't plead the law very sparingly and you shouldn't plead too much evidence or anything like that. Just be specific of facts. However, The HRTO in Ontario has been very aggressive towards applicants, denying applications at a rate of 97%. This means that you have to be very diligent in preparing your application. I always strongly recommend, normally the boards and tribunals, as you know, Richard, they're meant to be for self-reps, for people to just file. But unfortunately, with this aggressive thing, I would strongly suggest people employ the services of a paralegal or a lawyer, because this is one example where I'd recommend to actually plead the non-immunity clause that the HRTO is dismissing applications. The HRTO is saying that the board, first of all, you don't plead the staff members as the respondents. That's that vicarious employer liability thing where the employer is responsible for the actions of the staff. So you only plead the employer, being the WSIB or the worker's employer. Then in that, the HRTO will then automatically say on summary dismissal, oh, they have immunity, they have judicial immunity, which is not true. I say that because under section 179, I think it's paragraph 2 and 3, the board and the tribunal both have no immunity, and it's clearly stated. Now, their staff do have immunity so long as they act in good faith, but that's another subject and another topic for another day. So I just wanted to raise those points, that when people do bring the applications, to be very wary of those points, that make sure, one, that you have good detailed facts, dates, times, the W5, who, what, when, where, how, and then make sure you're within the 1 year period of the incident, and mention that you're pleading it against the board, who has no immunity by section 179 sub 2 and 3, and the tribunal too.
Well, I always thought that you had to go through the tribunal if you're doing human rights. But the decision I referred to earlier, the 42824, said, forget the tribunal. Just do it through litigation. You can argue violation of the Ontario Human Rights Act through the courts. So right
Yes.
now the tribunal's got this 2 to 3 year wait list for your case to be heard.
Are
Whereas
you
you can
talking
get
about,
through.
when you say tribunal, Richard, are you talking about the WSIAT, the Workplace
No,
Safety,
I'm talking about the Human Rights Tribunal.
the HRT? Okay.
Yeah,
Actually, the
so
wait is 10 years, Richard.
whether it's 2, 10 years, you could get into court in a year and a half,
Yes, I
theoretically,
agree.
and you could ignore the Human Rights Tribunal.
Well,
You just take the Human Rights Act and say, I'm suing my employer or I'm suing the WSIB because they violated this act and caused me damages.
well, you would have to, though. You can't, to my understanding, you can't plead a civil claim solely on human rights. You have to add it to a civil wrong, as it were, a civil, whether it be that the board committed bad faith or whether the employer wrongfully the most common would be wrongful termination by the employer, and then you add in a human rights thing, right? So, I mean, as always, it's best to consult with a lawyer or paralegal before you take such action, obviously.
Well,
You
there's
know,
a
and
case called YU versus WSIB where the Ontario court said the worker can sue the WSIB for failing to accommodate his language barrier if such is done within the 1 year time limit.
yeah, that
So
sounds like
there's a case
HRT.
where you're suing the WSIB not because they're not paying you, but because they're not accommodating you when they're communicating with you.
Yeah, there
So
was another case, Lawson v. WSIB, which a good friend of ours, John McKinnon at IWC, represented Mr. Lawson. And that literally opened the gate for fairness for injured workers, when what had happened was Mr. Lawson suffered from severe PTSD, that when he even saw a letter, an envelope from the WSIB, went into, like a panic attack or something. I'm not sure exactly his condition or anything, and I'm not belittling his condition in any way. And because of that, he had requested on multiple times that the board not communicate with him. And I remember John telling me this story, and it was quite humorous in the board's lawyer's response at the Human Rights Tribunal. And it was Brian Cook, the HRTO mediator, who had said to the WSIB, look, if he has an accommodation for his disability, which is you not communicate with them, then that's what you have to do. And they go, well, how are we tell him how to go back to work and everything? And Mr. Cook replied back, I don't care, it's not my problem, which is true. In that situation, they would just have to pay him out and, like they have to realize that they're dealing with fragile people and not machines. And it was a landmark decision. Now, if an injured worker does it today, I will be honest with you, the board, you have to fight tooth and nail, unfortunately. I've literally had to go to the president of the WSIB's office complaining about the board repeatedly communicating with my client. And I even offered them an alternative and said, no, 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 you can communicate through me, which is they still get their avenue of communication. And even now, they still communicate with the client, still causing them unbelievable stress and suffering. And you're right, that is warranting of a claim.
Let me just close with the following incident that happened to me in the last week, which was I read a book called Injury Impoverished, which was recommended to me by Robert Story, who's a professor at McMaster in political science. And the book traces workers' comp in the 1900s from 1900 to 1920. And one of the problems, what was going on with the introduction of workers' compensation was employers were told not to hire people who are married with children, because if they got killed at work, the employer would have to pay higher, or the compensation system would pay higher benefits because there's an estate without a wage earner. So the employers stopped hiring anyone who was married and would try and dismiss anyone who got married. And I'm thinking to myself, I see this now, that the WSIB is not that interested in psychological issues. It's like pass off psychological problems, say they're pre-existing, say they're not serious, because we have to save employers money, when in fact they should be doing everything possible to treat and accommodate the injured workers. So the book is written about what went on 100 years ago, and it's disturbing that it's still going on. So that's today's podcast. Again, if you have comments, questions, please get a hold of us on the links below. We're happy to talk to you and even have you on. Thanks.
Thank you.
Take care.